Sullivan here with you again. Shout out to Mr. Snooze, Corporate Music. Let's get it on. Good stuff today, a lot of stuff. In fact, we're due for some bigger budget production resources, whatever, assets. But let's do this. Let's get going here. I've gotten inquiries, and they're not on the comment section of YouTube, actually. They've been coming in from Facebook and email. And it's enlightening to see that people are really trying to grasp this stuff. It's so important. And what I'm going to do today is go over one of our recent postings and try and share with you in a little more detail where we were going or what we're trying to accomplish. So what I asked you to do was take a file like we did, and let me see if I can just get that. Oh, I'm such a perfectionist. There you go. It might be a little bit better. We took a file. Imagine that. And we started with the HUD-1 date. That's the closing date. Your HUD-1 statement is your settlement statement. If you go to court and you don't have a HUD-1 and the other side doesn't have a HUD-1, that'd be a motion to dismiss, I would think, or grounds to dismiss the case. No one can bring a foreclosure without a HUD-1. And that's important. I'll come back to that in a minute. So we start with a HUD-1, and we went to the judicial foreclosure court case number. Court case number started with 201631. Whatever that code means to the judicious or the court system, we believe it means something else. And what we did was we multiplied 2016-31, and that gave us 62496. That's where I got that number right there. That's nice. Got a nice little error there, but we then took the 62946. There's an error right there. It should be 62496 divided by 0.091 gave us 6867692. Case number 2016-31-0091, and the case number ended with 09. 216-31-0091-09. So we took this number here and factored it by 9%, 618-09231. What I did was I took the outstanding balance that was listed by the plaintiff, the outstanding balance that was listed by the servicer, Select Portfolio Services, the outstanding balance that was identified in a judicial pleading, the outstanding balance that the court is going to decide the matter on, 618-00581. Our numbers came up with 618-09231. We're off by 86.5. Guess what? Off for a reason, price per share. So, took a case number, factored it, came up with three numbers. It appears to me to be a weighted average installment or deposit, capitalization amount, and what we learned was this is your running revolving balance, reoccurring revolving balance. I'll tell you what that means in a minute. So here you see factoring the number of days, SPS balance, SPS per diem. We now took the difference, which is a margin of 86.50. Then what we did was we doubled it. We factored it by 2 because the servicing statement says there's an outstanding principal balance, and then it said there's a interest-bearing principal. They're matching balances, mirror balances. You getting this? So it looks to me that what we then did was factor the number of days and came up all the way back to 1100, which is not really important right now. I want to focus on this stuff right here. I'm just saying in this particular case, the court case number 206-31-009109 happens to be an equation. I might go as far as saying a formula or algorithm, which allows you to determine what the actual outstanding balance is and determine what the price per share is. I'm not saying that's illegal. I'm not saying that's wrong, unethical. Well, yeah, maybe. I'm not here to judge. I'm not a judge, jury, or executioner, and I'm not an advocate. I'm just saying I follow the accounting rules, and the accounting rules are what they are. You've got a court case number which translates into different variables equal to the outstanding balance, which is by coincidence. So here it says the plaintiff in the court recognized the outstanding balance and listed it as the amount in default. Without that number, I had nothing. So when you say, where did I come up with this? How did I find this? What are you, a soothsayer or a Einstein? No, I'm thanks for the compliment. I'm neither. Without this, I had nothing. It was with this that I was able to formulate and decipher exactly what they're doing. So this is something I would think you want to ask the court, and this would be something that I think would be grounds to remove it from a state court into a federal court. Can I assure you of that? No, I'm not an attorney. Only an attorney can advise you of your legal rights and property. But my advice to an attorney would be, hey, there's no ground to hear this case in a state court if the state court is in, what would we say, is aiding the plaintiff in the plaintiff's case. The only way it could do that where it wouldn't be a fraud is if the claim was really being brought by the state, not being disclosed, and covered through a nominee, which would be the Municipal Employees Retirement System for that state, or MERS. Anyway, you see the significance of this. We look forward to speaking with you again. You know where to reach me. Shout out to Corbett Video Music and some really good stuff. You can reach me at 202-550-8364, 202-550-8364, or secondary trade desk at gmail.com, secondary trade desk at gmail.com.